Good morning, everybody. I'm Carl Schackenberg from the Department for Culture, Media and Sport in the UK. My presentation is a bit different to everybody else's, sorry. Because we're from the UK, we always take a different path to the rest of the European Union. I don't have a PowerPoint, but instead you're being handed out copies of the laws, which I'm going to talk about. And so as a lawyer, I'm quite focused particularly on the words of the directive and the words of our regulations. I don't have the same policy expertise that some of the other panelists have, so I should manage your expectations in that respect. But I'd like to thank you for the invitation here and for the sponsors who helped put this together. It's an incredible event, and also all the other contributors. I've had some very interesting discussions already. Now, you'll soon have in your hands my little handout, but what I'm hoping to do is take you through the UK implementation of the directive by pointing out some interesting features of the implementing regulations. And I think by doing that, that should draw out some comments I have to make about the United Kingdom's drafting style, about the United Kingdom's approach to defining cultural objects, about the controversies or difficulties surrounding the original implementation of the directive back in 1993, 94, and some general observations on the effectiveness of the directive and of the changes introduced in 2014. And so can everybody hear me okay? Okay, thanks. And you've all got in your hands. So what you should have in your hands is the 2015 regulations implementing the directive of 2014. So I drafted those. It wasn't a very hard job. You'll see they're very short. So my job was quite easy. Following that, there is the explanatory memorandum. And that may be interesting for you to see. That is what what my policy colleagues produced to explain the directive and its implementation to Parliament. And then following that is the transposition note. That sets out every bit of the directive that we needed to implement and how we did it in the regulations. This is what we submitted to the Commission. If you see any mistakes in our transposition, please let me know before you let our colleague from the Commission know. And then the final document is the consolidated 94 regulations, and this is what I'm going to draw your attention to. This is the 1994 regulations implementing Directive 93/7 as amended by the ones we introduced last year. And hopefully you also have your copy of the directive itself from yesterday. If you don't, that's not fatal. But first of all, if you did have that copy of the directive, and if you compared that to the consolidated regulations, you'll notice they don't really look much like each other. And this is a really unique thing in UK law. The drafters of the 1994 regulations, they took what would now be a very unusual approach. They used a technique called rewriting. Rewriting means trying to understand what the directive means and then writing that out. They then combined that technique with what's called copyout. And copyout is where you simply reproduce exactly what the directive says. Now, we're really encouraged in government instructions to use the copyout approach. And there are two main reasons for that. One is that you're not in danger of under-implementing. If you write exactly what the directive says, you won't under-implement. I think that's a controversial point, but this is one theory. And the other reason is that you won't over-implement. You won't put more burdens on your businesses than the directive actually requires, and you won't put your country at a competitive disadvantage. If you're going to do more than what the directive requires, our Parliament requires you to be very, very clear about this. But anyway, I think probably the best approach is a combination of trying to interpret the directive and rewrite it, as well as copying it out where that's necessary. And that's what the original drafters of the 1994 regulations did. So I'll take you to look at the first point I wanted to show you, which is in Regulation 2. this is the definition of cultural objects. And you'll see we didn't really define anything there. We just said that that the definitions in the directive have the same meanings in our regulations. So to understand what words mean, we have to look to the directive. It does mean, because we don't redefine cultural object, that we are part of the mutual recognition of other member states' definitions of cultural object. But what is the UK's definition of cultural object? Because it's not in the regulations. How does the UK decide what a national treasure is? And here I'll draw your attention to the directive, if you have it in your hands. And it says in Article 2.1, cultural object means an object which is classified or defined by a member state before or after its unlawful removal as being among the national treasures under national legislation or administrative measures. And for the UK, the focus really is on definition after and also administrative measures, not legal measures. I'll explain, and this isn't in your hands because this isn't in our laws, it's administrative procedures. We don't have national lists of protected national treasures. I looked back at the reasons for this, and it was quite interesting. It was thought that if we were to suddenly make a national list preventing the export of a whole list of objects, most of which in the United Kingdom would be owned privately, then we would instantly reduce the value of all those objects by who knows how much, hundreds of millions of pounds, because their tradability would be instantly reduced. That would lead to a huge loss of wealth. Without compensation, there were concerns that that would be a form of wealth tax. There were other practical reasons why we decided not to have national lists, but these were decisions taken a long time ago. So what do we do instead of national lists? We have a committee. And it's called the Reviewing Committee on the Export of Works of Art. And it is reactive rather than proactive. It doesn't go around looking for objects to define them as treasures. If you want to export a cultural object from the UK within the EU or outside the EU, and it is above certain value thresholds or meets certain descriptions, I won't go into detail on those, but they look a little bit like the old annex to the old directive. And if it has been in the United Kingdom more than 50 years, so it doesn't cover new things, if it meets these basic requirements, you need an export license. And when you apply for your export license, an expert will look at your application and decide whether it should go to this committee for a decision that it's a national treasure or not. Now, what does the committee ask itself? Its question is, would the departure of the object from the United Kingdom be a misfortune? And it has 3 criteria called the Waverley criteria for deciding whether its departure would be a misfortune. Firstly, its close connection with our history and national life, so the United Kingdom's history, United Kingdom's national life. Second criteria, outstanding aesthetic importance. That may have nothing to do with the United Kingdom. And thirdly, outstanding significance in the study of any branch of art, learning, or history. Again, that could be something entirely disconnected with the United Kingdom, but the connection with the United Kingdom is it has been there that long. It's so important, its departure would be a misfortune to the United Kingdom. And if the committee makes that decision, it decides if any of those 3 criteria are met, that it is a national treasure. That doesn't mean it is saved for the United Kingdom. It just means that a local buyer is given the chance to potentially meet the same price, to meet the fair value price of the object, to buy it and keep it in the United Kingdom. If a local buyer can't be found to purchase it, then the work will be exported. Now, that is what happens if somebody applies for an export license. It may go before the committee. But what about the cases of the directive? What if somebody doesn't apply for an export license? If If they have a work that ought to have an export license, but they just decide to take it away anyway, what would happen then? Well, this hasn't had to happen. We haven't had to pursue a case in EU courts yet on this question, but because we don't proactively decide that things are national treasures, we would need to determine that the object that had been unlawfully removed was a national treasure before we could decide that the directive could be invoked. And the most likely course would be for the government to ask this reviewing committee that I mentioned again whether it thinks that the object is a national treasure. It would be a slightly different question to what they're normally asking. The question they ask is, would its departure be a misfortune? If it's already left, it's already departed, but they can still exercise a similar range of thoughts. And so I expect that is what would happen if we needed to pursue an action under the directive. But of course there are other options to actions under the directive, and I think in a case like that the UK would think about all its options. Now I'll take you a little bit further through the regulations, and let's stop next at Regulation 3(3). Now the whole of Regulation 3 implements Article 5 of the directive, and there's quite a technical point on 3(3). It says, the Secretary of State shall notify the member state concerned where a cultural object is found in the UK, brackets, whether as a result of a search under paragraph 1 or not. Now this piece in brackets, you won't see that in the directive. The directive only talks about a search. But our drafters thought, wait a minute, what if we find another member state's cultural object before they've made a request? They decided that this was technically possible, that someone might come across a cultural object despite there being no request, so we therefore needed the powers to protect that object and potentially get it returned. So that's why that wording is in there. And that's a little illustration of the rewriting drafting technique. The drafters of this, of the 94 regulations, tried to understand how the directive really would work and write that out, rather than simply copying out the text in every case. And now if we move a little bit further through the regulations, you'll get to Regulation 5, which is headed Powers of Search and Seizure. And this was probably the most controversial of all the elements of the regulations. The directive is silent as to how we should enforce the requirements to protect the object. But the drafters of our regulations created Regulation 5 there, and they said, and I hope you're looking at the consolidated 94 regulations at the back of the document if anybody's lost. They said we're going to have to be able to enter people's property and we're going to have to be able to search it. And you might think that's a very obvious and simple thing, but in the United Kingdom that's really controversial. It was a case in the early 17th century that said a person's home is to that person as his castle. It's a place of refuge and safety, and the idea of creating new powers of entry is extremely controversial, even more so in this case because it was the very first time in UK history that a search and entry power was created to assist a foreign state in what might only be a breach of that state's customs laws. So this was highly controversial. Parliament had a lot to say about it. My predecessors were hauled before Parliament to explain why this was necessary. And this is why if you look at Regulation 5, you'll see that it's a court order is required. Parliament didn't trust the executive, the Department for Culture, Media and Sport, to go and search premises itself. It didn't want a culture police. Instead, it requires the executive to go to court to ask for permission to search in order to enforce the directive. So this was what we did to essentially get this quite controversial provision past Parliament. Now, I'll take you a little bit further on. If we look at Regulation 6.5, and I should read it out in case anybody doesn't have it in front of them. Oh God, sorry. So Regulation 6.5 says, essentially, the court shall order the return of the object where it finds it, A, to be the cultural object covered by the request, and B, to have been removed unlawfully from the national territory of the member state. I think this is the greatest value of the directive because it is such a simple procedure. It's the minimum that you could be required to show, just two facts. Is it the cultural object and was it unlawfully removed? And this brings to mind the recital 8 of the directive, which tells us that its purpose is to avoid complications of dealing with property rights, and also Article 13 of the directive. Property rights are going to be resolved in the member state after the object is returned. So it's a brilliantly simple procedure. If you follow down the page further, you get to Regulation 6.6a, which is the 3-year time limit now instead of 1 year. This is one of the few changes that I had to make. It's in 6.6a, and the proceedings now, rather than the 1-year time limit, you have a 3-year time limit. I think this is going to make a huge difference. I looked back through the old files to try to understand what sort of course a restitution claim would take. And there are many options that are open. You might seek a simple voluntary return. You might call up the person who took an object away, say, oh, you do know this is ours, can you bring it back, please? You might arrange a settlement, an amicable settlement. You might, in a lot of cases, use mutual legal assistance. So other member states will contact our Home Office for assistance pursuing the matter as a penal, criminal matter. And they may find this is more fruitful. Or you might come to the United Kingdom in a private law case because you might be an individual seeking return of a national treasure. It may be in private ownership, not public ownership. So there are many options to pursue. And the directive, of course, is one of them. But I think that 1 year was just probably not enough to make quite complex strategic decisions about which potentially of multiple courses you were going to take to try to return the object. 3 years allows that strategic approach of keeping various options open. So I think we'll see it makes a big difference. And I'm just going to take you finally to Regulation 7.2. This is the burden of proof and the requirement for due care and attention, which tells us what due care and attention means. Now, it's difficult because we had so few return cases to know what courts would have done with the old wording. It's helpful now that we have such clear direction to courts on what to do. And I'm just going to probably speculate a bit here, but I think that dealers in the art market, looking at the requirements for what constitutes due care and attention, are going to become more and more valued for their role in helping ensure buyers that the buyers are paying due care and attention. And so it will probably, this is speculation, give dealers a competitive advantage if they are very strong at providing for due diligence. Their reputations are incredibly important to them. And so while we don't have a provision requiring this of them, as in the German law Robert Peters described to us, possibly we'll see the market introduce strict controls on itself if they're not already at the level described there. And then it really brings me to near the end, but I just wanted to say one thing about the directive. I'm very hopeful for it, particularly the point I made about the straightforwardness of what needs to be proven in a court, combined with the extended time limit allowing people to consider various options and strategies, combined with the IMI, which is going to make communication so much more easy. There were great fears back in the 1990s when the original regulations were brought in. But there's been no disaster for the art market. I think the latest TFAF report shows the UK is, again, #2 position in the world. Despite the very few cases we have seen as well, we shouldn't imagine that the original directive has had no effect in shaping behavior in the market. That's coming back to this point about the importance of reputations in the market. I think the latest amendments should make it a more practical tool for member states and, of course, just one of many tools. But thank you very much.